Okay, welcome back. I am still Joe Newhouse, the chair of ITA. I want to welcome you to the fourth and final session of ITA's seminar focused on the draft code of conduct for adjudicators in investor-state dispute settlement. Our sessions so far have addressed what we think are the three biggest issues with which the draft code seeks to grapple. Issue conflicts, addressed primarily by the disclosure provisions in Article 5 of the draft code, double hatting, addressed primarily in Article 6, and yesterday, repeat appointments, which is addressed both in the disclosure requirements of Article 5 and the availability provisions of Article 8. As I have on each of the last couple mornings, let me give a few of my personal takeaways from yesterday's discussion. First, the panelists noted that the issue of repeat appointments implicates a number of values. Impartiality and independence weighed against party choice, what one panelist called party choice versus party trust. That is what we usually think about when discussing repeat appointments. But the panelists pointed out that repeat appointments also implicate, one, the arbitrator's availability, as the draft code recognizes in Article 8, two, expertise, and three, the interest in increasing diversity in the pool of arbitrators. Several panelists noted that challenge and court decisions have not vacated awards based on repeated appointments alone, but look for some plus factor, such as a particularly close connection between the facts or issues in a prior appointment and the present appointment, as in the Caratube case. One panelist noted that according to preliminary analysis of data on the ICSID website, repeat appointments of arbitrators by states are significantly more common than repeat appointments by claimants. He counted 92 appointments of a single individual by states, 26 by another, and 23 by a third. Similar figures for claimant appointments are 33 and 28, and then the numbers trail off, he said. Similarly, using current data, it appears that a hard cap on concurrent appointments, such as is proposed in Article 8 of the draft code, would likely have a disproportionate impact on appointments made by states as opposed to claimants. It was once again a great discussion, unpacking the issue and providing context from law and practice. For any of you who missed any of the prior sessions, each session was recorded and will be publicly posted. We'll send a link to all those who registered for any of the sessions. Today's focus is on the very difficult issues of how the draft code might be implemented and how it might be made effective. And one more thing, David Props from UNCITRAL reminded us yesterday that the deadline for comments by states and others in the draft code has been extended to November 30th. I'm going to now, one last time, hand the podium over to Chiara Georgetti, the chair of ITA's Academic Council, and Tom Sikora, ITA's Senior Vice Chair, who are the organizers and moderators of this whole week of seminars. And I will express again, but not for the last time, the deep thanks of ITA for a truly outstanding program. Tom or Chiara?
Thank you very much, Joe. Good morning, good afternoon, everyone. I've got the privilege of introducing our distinguished panel for today's program on the implementation and enforcement of the draft code. And I will do so alphabetically. Let me start with James Costello, who is, of course, a global disputes partner at King & Spalding based in Paris. He's been a longtime member of the US delegation to UNCITRAL and has actively participated since 2001 in revising various UNCITRAL instruments. He's a member of the LCIA Board of Directors since 2007, a member of the advisory board of the Vienna International Arbitration Center, and the vice chair at the ITA. From 1995 to 2001, he was a senior Clinton administration official as the deputy counsel to the president and then associate deputy attorney general. Following James, I'd like to introduce Professor Catherine Rogers, who's a professor of law, whose teaching and scholarship focuses on the intersection between professional regulation and market dynamics and international arbitration. She teaches at Queen Mary University of London, where she also co-directs the Institute of Ethics, Regulation, and commercial law. She's currently a visiting professor at Bocconi University and is on leave from Penn State Law. She is the founder and CEO of Arbitrator Intelligence, a legal tech startup that provides unique, quantifiable, and contextualized data analytics for arbitrator selection. And I would be remiss if I didn't mention that Arbitrator Intelligence reports were specifically mentioned in Working Group 3's draft working paper on selection and appointment of ISDS tribunal members. Next is Meg Kinnear, who of course is the Vice President of the World Bank Group and Secretary General of the International Center for Settlement of Investment Disputes. Ms. Kinnear was formerly the Senior General Counsel and Director General of the Trade Law Bureau of Canada. David Probst is an associate expert in international trade law at UNCITRAL Secretariat, where he services Working Group 3. Before joining UNCITRAL, David worked as a lawyer for an international law firm in Germany focusing on investment arbitration in the energy sector. He holds an LLM from the Fletcher School of Law and Diplomacy. Finally, our last member of the faculty is Myre Uran-Bidegain, who is head of the program for defense of the state in international investment arbitration of the Ministry of Foreign Affairs of Chile. Prior to joining the ministry in 2018, Ms. Uran was the team leader and legal counsel at the International Center for Settlement of Investment Disputes. And prior to that, Myre worked as an associate at the White and Case International Arbitration Group in Washington, D.C. She holds degrees in law and a master's in law from Université Panthéon Assas and Panthéon Sorbonne, and has an LLM from the University of Pennsylvania Law School. So that is our distinguished panel for today. And with that, I will turn it over to Professor Georgetti to introduce the subject.
Many thanks, Tom and Joe, for the introduction. Many thanks to the panelists for joining us today, and for the attendees for joining us today. So as Joe mentioned before, in the first 3 webinars of the series, we discussed some very important topics: issue conflict, repeat appointments, and double heading. And today we'll discuss the implementation and enforcement of the draft code. And this is arguably the most important issue that we are here to discuss. A litmus test, if you will, as the code would not really be successful if it cannot be implemented and enforced properly. So how can we frame the issue usefully for the discussion today? In terms of implementation, I like to highlight 3 important issues and choices. First, we're thinking about the draft code. Are we thinking about a soft law instrument or a hard law instrument? I think states delegates have already spoken in favor of a mandatory code which can be enforced properly. The second issue, how can we incorporate then the text of the code usefully in a binding instrument? And here there are many choices. Shall we incorporate it in a treaty? And if a treaty, should it be a bilateral investment treaty or a multilateral instrument? And if it's a multilateral instrument, maybe should we take example from the Mauritius Convention, where we have multiple ways of implementation, multiple venues for implementation, including possibly retroactively. But we can also think about not a treaty, but thinking about the role of arbitral institutions in implementing the code, which make it more expeditious, which make it more expeditiously implemented. And then the third issue that I would like to highlight briefly is whether we want to have one unique text that is included by all stakeholders and as one text that it's that is common, or maybe that different texts could be used slightly different in different arbitral institutions. And I think my preference again would be here for one text because I think uniformity in the code of conduct would be very important. And then the second issue, the issue of enforcement. Now, what remedies are available if an adjudicator violates the provisions of the code? Again, here it's very important and another very key question, because to have a code that really has meaning, you have to have enforcement mechanisms. And here there are a variety of remedy of mechanisms also possible, but some are more theoretical than others. So one that is referred to very often is the idea of challenges. And this is really, so what is available is really now the kind of the ultimate weapon, the nuclear option, if you will. So you can challenge arbitrators if they, or adjudicators if they violate some of the provisions. But are there other remedies that are possible? Should maybe violators be named? Should we have a blacklist, but a nominating list, but or maybe monetary fines? But if that is this is one of the remedies, who applies it? How can it be applied? There are a range of questions that really are important to be addressed and resolved. And how do we try to implement and enforce this very important code? To talk about these questions, we have a panel of outstanding experts, and in the first round of discussions, we will focus on the issue of implementation. And I would like to ask Meg first, how does the code, the draft code itself, view and take on the issue of implementation in the draft? Thank you, Meg.
Here we go. Good morning, all. I'd like to simply set context both on implementation and enforcement. As you can see, there's still a lot of room for discussion, and these are open topics. I think it's fair to say that as we drafted this, we were not able to get into great depth on either implementation or enforcement because the content and approach of the code is not yet final. And every time you started to think, how would you implement this or how would you enforce this, you had to say, well, what is the this? So it really does help to have a little more certainty in what the prior parts of the code are going to be before you get into the implementation and enforcement. We also know that delegates wanted something that was binding, so we started from there. What we have right now is what you might call a traditional provision found in other codes and other investment treaties. So the first thing, and this is all found in Article 12, is that this code relies on voluntary compliance by adjudicators. So essentially that they should not accept a mandate where there is a conflict, or that they should, if they fear there's a conflict or want to be extra cautious, fully disclose the relevant facts so the parties can decide whether there's a concern and whether they waive that concern or not. I think it's important to note as we talk about many of these things that voluntary compliance works very well and that really the problems are at the margins. I know we spend all our time talking about those problems, but in fact, I think the voluntary compliance works very well in the grand number of cases, and that's an important piece of background that should be kept in mind as we talk about options. So Article 12, which you can see on the screen in front of you, essentially says that there will be an obligation to comply, and that's meant to indicate the voluntary compliance requirement. It puts a premium, obviously, on making it very clear in the earlier provisions of the code as to what is or is not a breach, and that, as this week has probably told everybody, is not the easiest of tasks, but it's important so that both arbitrators and counsel can assess whether they think there is a conflict problem or not. Second, where a party thinks that there is a conflict, they can make the objection. And what's very usual in this field is that a party who is concerned will write and advise of their concern. And that then puts in motion a process where either the arbitrator recuses themselves, and we see sometimes recusal because the arbitrator perhaps had not considered something, or not infrequently recusal simply because the arbitrator does not want to put the process through an expensive and time-consuming process of a challenge. But that first option is recusal. And if the arbitrator does not believe there is a problem, then it is left to the party to bring a challenge if they feel that that would be appropriate. In terms of actual implementation, again, it will be very important to see the final shape of the code. And as Chiara has noted, it will really depend on what the states want to do. So for example, if there is a multilateral procedural treaty adopted by states, there will be no need to implement on a case-by-case or party-by-party or rule set by rule set basis. At this point, I think we have assumed, at least certainly in the ICSID rules amendment, that when this code is complete and agreed upon, it would ultimately be incorporated into the ICSID rules. And in our rules amendment process, we have noted that the code could very simply be attached to the declaration made by arbitrators. Currently, that's Rule 6, and hence incorporated into the process. We, of course, expect that once the code has been agreed upon, we will meet with our member states to specifically discuss how to implement. And I think when we have this conversation, it's also going to be necessary to address whether there are any ICSID specific issues that might make you want to make any tweaks or any changes. I don't think there are many of those. I can't see many. And the ones that you might envision, I don't think are surmountable. For example, how does the code fit with the panel of arbitrators, especially if, for example, there is some kind of a constraint on double hatting. Those are fairly remote at this point, but simply to indicate to you that we will obviously, once it's basically decided in Working Group 3, and once a method of implementation is decided, we will then bring it to our ICSID Administrative Council members and say, all right, now, how do we make sure this is included in the ICSID regime? Beyond implementation, there are obviously several interesting ideas about enforcement. We did a lot of brainstorming on those, but they become very difficult. You have to really start thinking about who gets involved, what right do they have to get involved. And then when I say right, I mean that more as a jurisdictional and a legal issue. And what is the impact on the process? You talk about naming and shaming, financial penalties. We've heard all sorts of ideas about enforcement, and there are some really complicated, difficult issues around those, but it's certainly a discussion that the delegates want to have, and I'll be most interested today to hear what my colleagues have to say about the implementation and enforcement of the code. So thank you.
Many thanks, Meg. You mentioned, and we mentioned also before, that this is, the code is really something that states have wanted and have directed both UNCITRAL and the ICSID Secretariat to take into consideration and to draft. But the states have said, so draft this code, but haven't really said too much about how to implement and enforce it. And I wonder if David can give us a little more background about the state delegates' role and the approach that Working Group 3 is taking on this issue.
Thank you so much, Chiara, and good morning, afternoon, and evening to all. After we heard from Meg about the concept and challenges of Article 12 of the draft code and its implementation also from the perspective of the ICSID rules and regulation amendment process, I would like to give you just a brief summary of the discussions in UNCITRAL Working Group 3 on enforcement options and on the implementation of a code of conduct as part of the ISDS reform. The development of a code of conduct has been on the working group's agenda for 5 years now, and different aspects thereof have been discussed in a number of working group sessions. In this October 2019 session, it was stressed in the working group that an enforcement mechanism would constitute a key component of a code of conduct. It was also generally felt that it would not be prudent to rely only on the voluntary compliance of arbitrators, and that the consequences of non-compliance would need to be clearly set forth in the code. This need for sanctions is something that also regularly came up in the submissions by the states. There were different suggestions regarding the potential form of the sanctions, including the development of concrete rules on challenges to arbitrators and their disqualification. Others argued that consequences beyond challenges and disqualifications should be considered to establish an effective sanction mechanism. These additional sanctions beyond challenges and disqualification may include, for example, sanctions linked with the remuneration scheme, disciplinary measures, reputational sanctions, or notifications to professional associations. These were the examples mentioned in the working group. Then it was also suggested that transparency could be increased by a centralized system or body for the monitoring of compliance with the code of conduct, and a database on challenges and sanctioned arbitrators, and that, for example, an advisory center, another reform option currently discussed by the working group, could be tasked with this role. Also, it was mentioned that there was a need to address the situation in which the breach of a code of conduct is found after the award was rendered. In this case, the enforcement of the award may be refused under Article 5 of the New York Convention, but there would be no direct consequences for the arbitrator. The working group had further discussions on the limitations in existing challenge mechanisms, after concerns had been expressed relating to the adequacy, effectiveness, and the transparency of disclosure and challenge mechanisms available under existing treaties and arbitration rules. Others were concerned about the potential unintended consequences of the introduction of higher standards and their strict enforcement. For example, arbitrators may hesitate to accept appointments against the background of an increased scrutiny. Regarding the implementation of a code of conduct, it was noted in the working group session in October 2018 that there is a variety of existing texts on the code of on the conduct of arbitrators, and that coordinated efforts and harmonized solutions at a multilateral level were needed. Later, it was emphasized that the development of a code of conduct should not result in further fragmentation. However, the view was expressed that any code of conduct would need to reflect diverse traditions and practices, and that it would be preferable to leave it to states to include in their investment treaties such a code, as well as to the disputing parties to determine the appropriate ethical standard in their case. A code of conduct could become a soft law instrument, which guides the interpretation of the duties already provided in existing codes and rules. It was further suggested to incorporate the code in the system of investment agreements, as it has been done in several recent investment treaties. While some suggested that the code could or would apply only to future investment treaties and disputes, it was also suggested that a multilateral instrument on ISDS reform could make it possible to incorporate the code of conduct also in the large number of existing treaties. And regarding this multilateral instrument, several proposals have been introduced in the working group for the implementation of ISDS reform options. While some focus more on the coherence of the ISDS system, others focus more on the flexibility of states to adopt certain reform options and refrain from the adoption of others. Some propose a multilateral instrument with blocks of provisions and a minimum standard that all participating states have to adhere to. And another proposal suggested a suite approach where reform options can be pursued independently from one another. Finally, it was also proposed to establish a permanent body in a multilateral instrument with an open architecture allowing for the free choice of the dispute settlement mechanism, a construct similar to the one implemented in the UN Convention on the Law of the Seas. If such permanent body was established, a code of conduct would, for example, could be included in the rules governing this body, and this would, of course, also offer additional enforcement options, as it could serve as a centralized system charged with the monitoring of and compliance with the code of conduct, decisions on challenges, and also potential additional sanctions as suggested in the working group. Now, this was my brief summary of the working group's discussion, and with that, thank you, and back to you, Chiara.
Thank you very much, David. This was extremely helpful in putting the code in context. I wonder, Mireille, if you can tell us a little more about kind of the state approach in terms of implementation of the code, and even including some of the views the states have on the different implementation mechanisms, including the multilateral instrument.
Thank you, Chiara, and good morning, afternoon, and evening to all. I would like to start just obviously thanking you, Chiara, and thanking Tom, and of course ITA for the kind invitation, and to all of you for being here with us today. Before I move on to discuss a particular topic that brought us here, I wanted to make two preliminary remarks. The first one is, of course, a disclaimer that my comments today will be made in my personal capacity and may not be attributed to the Republic of Chile. The second one is just a general comment on the code to highlight that the existence of the code is in many respects a very welcome development by state delegations. Indeed, it was one of the few ISDS reform options currently discussed at Working Group 3, where there was real consensus to include it very early on the agenda or project schedule that was developed during Working Group's 38th session in October 2019. And as the Working Group 3 will be faced again with the need to establish a work plan to perform its mandate efficiently and determine the timing of the developments of the various reform options after the next session, which will be held in a couple of weeks, we're confident that the code will continue to attract much interest and be placed once again in a privileged position vis-a-vis other reform options. And we believe that this is the case for two reasons. The first one is that arriving where we are and having before us an actual draft for a tangible basis for discussion is already remarkable, because putting forward a truly universal common set of ethical norms, it's not an easy task. And we therefore wanted to start by commending the joint work of ICSID and the UNCITRAL secretariats, and of course of those like Professor Georgetti, who have been critical in this process for achieving this task and for doing so in a timely manner. As Chiara already mentioned, and as was set forth in the report of the work of UNCITRAL's 38th session, the state's parties had expressed a general preference for concrete rules of a mandatory nature rather than guidelines such as the IBA, for example. And in that sense, the two institutions have made a noteworthy effort to carry out the mandate provided by states. The second reason is that the code, which focuses on disclosure, strives to put all parties on a level playing field by making sure the parties have the same information. And in a field where potential asymmetries have played a role, efforts made to close the gap have been well received, and they should be encouraged to move forward. And with this, perhaps a bit long introduction, I'll move now to the actual question of implementation. On that, there's been, of course, some discussion among state delegations. And one of the questions that has been brought and that was said is that implementation could be difficult due to the decentralized and ad hoc nature of ISDS. And while this is the case, we believe that incorporating a final and agreed code of conduct in a multilateral investment reform agreement or a multilateral treaty on ISDS reform, like the one that Chile with Mexico, Peru, Japan, and Israel proposed in a working paper submitted to the working group, and it was also proposed by Colombia in a separate paper, could be an excellent implementation option. This mechanism, as it was already suggested, could allow for the code to apply not only to future investment treaties and disputes, but also to existing treaties, thereby ensuring a true universal application and assisting in the objective of preventing a possible fragmentation of ethical standards. We are, yes, cognizant of the fact that multilateral negotiations take time, and even once they're finalized, treaties need to be signed and ratified by states, which, judging by recent efforts in the same field, such as the Mauritius Convention, could be a very slow process. And while I understand that those who had hoped for a quicker or perhaps more widespread application of the Mauritius Convention are disappointed, I don't think this is a comparable example to determine whether something like a multilateral instrument reform agreement will indeed work. And this because the Mauritius Convention covers one topic, which is transparency. And putting the heavy engine of different branches of a state to work for the ratification of a treaty involving a very narrow and rather particular issue may seem too cumbersome. On the contrary, the cost-benefit analysis will be more favorable if the ratification process allows a state to participate in a multilateral instrument that could serve as a flexible framework to implement multiple reform options, and which has the potential of setting modern standard covering all procedural aspects of ISDS disputes, thereby providing more coherence and predictability to the ISDS system and a better system for all. In addition, considering the level of interest, commitment, and dedication that state delegations are affording to the ISDS reform process, coupled with the real sense in many state capitals that reform is much needed, I believe and truly believe that this is a medium to long-term mechanism for the implementation of the Code of Conduct that should be truly considered as a viable option. Of course, this does leaves us with the question of what to do in the short term. And Meg explained to us a few minutes ago that the ICSID rule amendment process, through the ICSID rule amendment process, the center has considered that the code could be attached as part of the declaration signed by individual arbitrators and hence incorporated in the process. And thanks to the enormous amount of work, resource, effort, and endless night of the ICSID Secretariat, the ICSID amendment project has moved at a very steady pace, and unless something extraordinary happens, it could be brought to a vote in 2021 and probably be in effect shortly thereafter. Now, if my numbers are correct, more than 3/4 of ISDS cases are decided on the basis of cases brought under the ICSID mechanism. This means that by 2022, we will be able to ensure the appropriate implementation of the code in a vast majority of cases if the code has been agreed upon. For non-ICSID cases, or if the code is finalized before the ICSID rules have become into force, parties could adopt it on a case-by-case basis by requesting arbitrators to commit to acting consistently with the code when they accept their appointment. Therefore, the code should be proposed in the seeking acceptance letters to arbitrators. And other administering institutions could also adopt the same procedure proposed by ICSID to ensure the implementation of the code. So to conclude, we believe that the Code of Conduct is a very valuable reform option and that there are viable avenues to ensure an adequate implementation of the code, both from a long and short-term perspective. And thank you very much, and I hand the floor back to you, Chiara.
Thank you very much, Mayra. This was very, very interesting to hear the perspective, your perspective, and really how the code can be both implemented both in the short term and as a long-term project with the multilateral instrument. James, can I ask you if your view about the scope of the code and how it matches the scope and the enforcement of the code itself. But before I pass you the floor, can I attendees that we would love to hear your questions, and we have the Q&A function at the bottom of your screen, and you can ask questions through that mechanism. James, over to you to talk a little bit about the matching the code scope to its enforcement option. Thank you.
Sorry, had a little difficulty unmuting myself. Thank you very much, Chiara and Tom, for having invited me to participate in this seminar. Like Mare, I want to start by just saying that even though I've had the privilege of being on the US delegation to UNCITRAL for 20 years, what I say today is only in my private capacity and not speaking for the US government. So yes, Chiara, there are a couple of points I would make in this respect. The first is, although, Meg quite properly mentioned voluntary compliance and the fact that this has been widely exhibited with existing standards of independence and impartiality, I think you can see by looking at this draft code before us that its regulatory scope is far, far broader than anything that we have been used to date, like the IBA guidelines on conflicts. And so I do think we'll need to think of enforcement mechanisms, and David has already mentioned that that is a view that is widely prevails at UNCITRAL as well. And I think that's partly because it's that, you know, if we adopt it in a formal way of enforcement or application, I think that would respond to a public concern that the process itself have visible standards and not merely ad hoc voluntary standards. So the commentary to the code of conduct proposes that the code be applied in individual arbitrations by being applied through a treaty or multiple treaties, but in particular a multilateral convention like the Mauritius Convention. And in that connection, I would make 2 points. First, I think states would have to agree on a formulation within that multilateral instrument for amending each BIT to make the code applicable to arbitrators in individual cases. So there's not much experience on this. We have very few treaties that have expressly referred to or applied something like the IBA guidelines on conflicts of interest. The ones I'm aware of are very, very recent. They include the CPTPP, that's the trade agreement among the 11 different Pacific and Asian countries. And there it's in a code of conduct that is an annexed chapter 9, and that provides in relevant part that an arbitrator shall comply with internationally recognized standards or guidelines regarding direct or indirect conflicts of interest, such as the IBA guidelines on conflicts of interest in international arbitration. So this is less than a definitive application of that one instrument, but still it's a concrete reference. And then by contrast, Article 8.30 of the CETA, the Canadian EU trade agreement, expressly requires the tribunal members, quote, shall comply with the IBA guidelines on conflicts of interest, and then it further provides that any party that believes that such guidelines have been violated can bring a challenge before the president of the International Court of Justice in The Hague. So that's a much more concrete application, but you can see there really isn't any uniform approach. So that's something we would have to resolve. Secondly, the draft code's proposed scope of application is broader than just arbitrations that arise under investment treaties. It also applies to foreign investment claims against states that arise under contracts like investment agreements with host governments or national investment statutes. And a multilateral treaty like the Mauritius Convention is not going to reach those kinds of cases. So then we need to consider, and Myre has raised this, how would we then persuade different institutions whose rules are most frequently applied in investor-state dispute arbitrations to incorporate the code of conduct into their rules. Now, this may be relatively easy with respect to ICSID, and Meg has already indicated that, since many of the member states of ICSID have already expressed, in principle, I think, support for such a code. But it may be more difficult with respect to other institutions like the Stockholm Chamber or the ICC or even UNCITRAL. I'm not sure I share Myre's optimism, although it's commendable, her optimism, that this could be adopted within a year at UNCITRAL. Maybe it can, but so far the delegations at UNCITRAL have not really participated in the drafting of the substance of this code. So we'd have to see how delegations respond to that very broad regulatory scope. The one other point I wanted to make is that, assuming that we agree on these mechanisms for applying the draft code of conduct to individual ISDS proceedings, I think there's still a concern about incorporating an as yet untested conduct code into treaties where it may be seen to rest sort of in perpetuity, because of course it's quite difficult to amend treaties. And so I would just point out that, you know, to date, for example, I don't think it's an accident that the two examples I gave of the TPP and also CETA having incorporated by reference the IBA guidelines, those guidelines have been in existence for 16 years. I think they would be regarded as well tested. And I'm going to get to this a little bit later, but you can see by a sort of opinion polling within practitioners groups, particularly the annual survey that's done by Queen Mary University and PwC, that there has been a gradual acceptance of these types of soft law instruments. It takes time over time. And so to incorporate this new code of conduct into a treaty in a way that maybe just will not be adaptable in the future as views change is, I think, difficult. And I would just note that, excuse me, for example, in the CEDA, when it incorporates the IBA guidelines, it specifically says the guidelines as they may have been amended. And similarly, in the Mauritius Convention, when we applied the UNCITRAL transparency rules to existing BITs of signatory countries, again, we provide that it is the version of the UNCITRAL transparency rules that are in effect at the time the arbitration arises. I'm not sure how we would make this kind of a dynamic reference to the code of conduct, because there isn't any obvious curator or gatekeeper to future versions. It's so far, it's been a joint product, as I understand, of the secretariats at ICSID and UNCITRAL. And so the question is, if you want to designate by name an instrument that then is dynamic over time, you need to have a sort of a curator institution that takes responsibility for future versions. Those are my two observations on enforcement. Thank you, Chiara.
Thank you very much, James. This was quite interesting, kind of highlighting some of the challenges, but also thinking about other existing codes to which this code kind of builds on, the one at CETA and the CPTPP. Interesting how kind of these also play a role. Catherine, can I ask you also to comment kind of maybe the issue of the structural assessment and professional regulatory issues that may arise from the implementation and enforcement of the code?
Yes, thank you. Thank you for having me as well, to all the organizers, and also compliments to all the people who've been working on this code. Because as someone who works in this area, these are incredibly difficult issues with no easy answers. I'm going to start with some of the observations that Meg made, which is to date, voluntary compliance seems to be working really well. So why do we even think we need a code? Well, that's because clearly mostly states, it seems, do not think that they're adequate, that there's something wrong. And I think with the way I read the code is it is aiming to, one, create greater consistency and even universality, and two, to broaden mainly, I think the primary function as I see it, is broaden disclosure. And you can tell by looking at Article 12 that, until you, as Meg said in the beginning, until you have just what you want to do kind of solidified, it's very difficult to think about enforcement. But from what I'm seeing, I think the disconnect between enforcement and broadened disclosure may create greater discord or problems, excuse me, than it would solve. And so that's why I said I want to talk briefly about the structural concerns. So, and I'll start with an example that I think might be helpful. So one of the main functions of the code is to systematize and broaden generally disclosure requirements, with the idea that that will increase the confidence of parties. But some of the requirements for disclosure are, I would say, dramatically broader than what's currently required. So let me give you a few examples. First, Article 5, subparagraph 2C requires that all ISDS and other international arbitration cases in which the candidate or adjudicator has been or is currently involved as an arbitrator, annulment committee member, or expert. Okay, the idea that you must disclose every single one of those cases is actually quite different than the requirements for disclosure on the IBA Orange list. And the concern there is that what this code would seem to be doing is broadening dramatically over what has been historical expectations, the requirement for disclosure, but not changing, and as I understand, quite intentionally not changing, the requirements that might, the consequences for that disclosure in terms of disqualification or other challenges to, for example, the award. And that's because in Article 12, subparagraph 2, for example, it says disqualification and removal procedures shall continue to apply, the existing ones. My concern is that if you dramatically expand what must be disclosed, but you do not change and do not appear to want to change the amount of the consequences for those broader disclosures, you might, instead of creating greater confidence that we oftentimes associate with broader disclosure or greater transparency, you might broaden the gap between what parties expect and what parties are able to achieve in terms of changing behavior. And I think that and that may suggest, and I think this is sort of previewed a bit in James's concerns, observations, is that maybe what might be useful is not just one instrument, but in fact more than one. So a code of conduct tends to be quite hortatory. You must, adhere to the highest standards. You must disclose everything, but that is meant to promote sort of and our social norms and social compliance, whereas when you are looking at something where you want it to be mandatory and have concrete enforcement, I think you have to have much more precise standards. Now, even the IBA code, the IBA guidelines do not regulate with great precision exactly what constitutes a disqualification, but they do unpack a lot of the difficult questions. So that while they have general standards that all the arbitrators must be impartial and independent, they must err in favor of disclosure, they also provide very specific provisions to essentially unpack or disaggregate this very vague concept of impartiality. So according to the new code, it seems that any time an arbitrator has sat with any of the parties or with any of the experts or with any been appointed by any of the counsel, that must be disclosed, even though it seems that understood that those disclosures would not result in disqualification. And the commentary of the code acknowledges that disclosure is broader than disqualification, but without any new guidance on what would constitute disqualification, I think the fear is that instead of promoting universality, uniformity, greater confidence, what you might do is increase anxiety and lack of confidence, because disclosures that at least one party thinks should lead to disqualification, the other party doesn't. That might suggest that maybe where some of the work is to be done is less on what necessarily needs to be disclosed, but more intensively on what should constitute disqualification. And it looks throughout the code that is where, in fact, the breakdown tends to happen. So on, for example, repeat appointments that was discussed already, the idea that you might have some absolute number of repeat appointments after which there's a bar or disqualification kicks in, it seems in the abstract to make sense, but when you dig a little deeper, it looks like, okay, it's not necessarily an absolute number, or it's not just repeat appointments itself. That is the work, I believe, of setting the harder work of setting what would be the disqualification standards that accompany the disclosure standards. And the other reason I would emphasize, the other concern I would emphasize is evident in some of the other provisions in Article 5, for example, where the disclosure that's required is much broader than what could possibly lead to a disqualification. I think I'm going to close quickly so we can get on to the next topic with the idea that I think part of this is not an inherent problem with the code. It's actually the difficulty with the language generally that we're stuck with when we try to regulate these issues. So most standards that try, including in the code, that try to describe or identify what impartiality standards are, define what those standards are by using the actual word they're trying to define. So for example, in the model law, we talk about, what constitutes impartiality. Well, when there are justifiable doubts, okay, about impartiality. Or what constitutes impartiality under other formulations? Well, when the impartiality or independence of the arbitrator may be questioned in the eyes of the parties or by an objective observer. All these definitions seek to try and define impartiality using the term itself, which is difficult not to do, but I think is where the real challenge lies. I think the most developed and advanced example we have today of trying to unpack that word and parse what it actually means in specific contexts, both for disqualification and for disclosure more generally, are the IBA guidelines. And so to the extent the concern or the interest is in creating universality and increasing consistency, I do think that instead of doing that, you risk greater fragmentation by providing for and requiring much broader disclosure than is required in this very specific parsing that the IBA guidelines did, without any explanation about how these broader disclosures might promote greater understanding or appreciation or confidence in arbitrators' impartiality. And instead, I believe the fragmentation and the lack of consequences, either disclosure or effective challenges to awards, neither of which, increased disclosure or increased challenges to awards, is what I understand is wanted or desired or considered appropriate. But if you increase that gap between disclosure and the consequences for it, I think you risk having this backfire rather than accomplishing the aims. And I'll close with that to just say that it's hard to say you disagree with impartiality. So to the extent you want universality about increased disclosure to promote transparency and impartiality, you can't disagree with that. But I think those kinds of platitudes, as appealing as they are, don't do the heavy lifting, the really hard work and the parsing that needs to be done to have an effective code. And I'll go one step further to say, as there's reconsideration and redrafting of the code, maybe it's not even a code that's needed. It might be a code and also some other sorts of regulatory instruments that govern more specifically some of the consequences. But without enforcement that coalesces with the actual standards that are sought to be regulated, I think you risk greater fragmentation and actually disappointment rather than raising the standards and confidence that's sought to be done by broader disclosure more generally.
Thank you very much indeed, Catherine, and thank you everyone for helping us with the truly challenging and complex issue of implementation of our proposed code. Let me just remind the audience that we do have a Q&A function on our program today, and we invite and encourage everyone to submit their questions to the distinguished panel via the Q&A function. So we've talked about implementation, but there is of course another side to all of this, which is the side of once implemented, how do we make the code enforceable against individual adjudicators, individual arbitrators in specific cases, and how does it have a bite so it's not an empty letter? And maybe James, you could start us out with your thoughts and remarks about that.
Okay, thank you very much, Tom. Yeah, I would say, first of all, as Meg noted, this is a thorny issue, and the code of conduct on this issue, as she said, I think is, or I'm paraphrasing her, is really still a work in progress. And indeed, I think Article 12 of the draft code of conduct, which is the enforcement article, it's fair to say that at the moment it kind of punts on this question of enforcement in individual proceedings. It contains two relevant provisions. The first is, quote, every adjudicator and candidate has an obligation to comply with the applicable provisions of this code. And I'm going to come back to that, key phrase, applicable, but it really, in there is a constellation of a lot of different uncertainties, I think, which need to be addressed. The second phrase is one that Catherine's already quoted, but I'm just going to quote it again so we have it in mind, and that is, it says, the disqualification and removal procedures in the applicable rules shall continue to apply. So as I understand it, that means that, for example, if the ICC or let's say the Stockholm Chamber were to adopt this code of conduct, nevertheless, their existing challenge procedures and their rules for a particular arbitrator would continue to apply. Now, the first, I just want to make two comments about the difficulties here. The first is that most challenge procedures in rules have standards that are already embedded in them. And they're usually they're usually limited, I think, to standards of impartiality and independence. Whereas, as I've said, and I'm about to come to some examples, the draft code of conduct is really much, much broader. So it's not clear to me, and I think Catherine already touched on this, you know, we would have to work out exactly how these much broader standards in the code of conduct are to mesh with existing challenge procedures. But the second point is that, and Catherine has also touched on this, that many of the code provisions seem more aspirational norms than working grounds for disqualification. And that's not necessarily a bad thing to have aspirational norms in codes of conduct, as Catherine herself has noted. But the difficulty is this key phrase that every adjudicator has an obligation to comply with the applicable provisions of this code. So if you're looking at all the different provisions, and I'm just going to now give some examples, it's not clear how this would work as a standard for disqualification. So, for example, Article 3 of the draft code says, at all times, adjudicators shall display the highest standards of integrity, fairness, and competence. I can tell you from years of experience of drafting at UNCITRAL that we have learned painfully, I think, but over the years, that when you're drafting things like this, you want to avoid absolutes like the highest standards when you're talking about a judgment call that needs to be made. And so you can imagine, for example, how a disgruntled party might take the latest order that was issued by a tribunal and say, well, you know, this order may have been okay, but it doesn't exhibit the highest standards of fairness or the highest standards of competence, because it could have been more fair if it were written in this alternative manner, or more competent if the tribunal had remembered this other point. And then the question becomes, is that a potential source of a challenge to, let's say, a chair who presumably authored the order on behalf of the tribunal? Another example, Article 5.2d of the draft code says that the candidate for arbitrator must disclose a list of all publications by the adjudicator or candidate, and in brackets, their relevant public speeches, unquote. So then, again, the question is, if you leave one off of your list, and I think I speak for many potential arbitrators in saying that I honestly cannot remember every speech, and I don't necessarily keep a record of every speech or even every article that I wrote, you know, 15, 20 years ago. So then the question again becomes, is that a ground for disqualification, having omitted something like that? And a third example, Article 10.1 says, any pre-appointment interview shall be limited to discussion concerning availability of the adjudicator and the absence of conflict. So let's suppose it's later discovered that a particular arbitrator who ended up being appointed answered a question during a pre-appointment interview as to whether he or she had ever handled, let's say, a time delay claim on a construction project. Now, in my experience, that would be a very common question to ask an arbitrator. That arbitrator's experience with time delay claims would not necessarily be obvious in the disclosure of the list of prior cases just by caption in which that arbitrator had served in one capacity or another. And it's obviously relevant to the question of the arbitrator's experience. But it's apparently barred by the proposed standard here. Again, is the belated discovery that the arbitrator answered a question like that grounds for a challenge? And even worse, and Catherine has raised this as well, if it's not discovered until after the award is issued, does that become a ground for seeking annulment or resisting enforcement of the ultimate award? So these are the kinds of questions that I think will have to be addressed, and it's an important area. The other point I want to make is that I think so far there is a tradition of not mandating the application of soft law instruments. And I think that, again, the Queen Mary University PwC annual surveys have shown that these soft law instruments do gain adherence, and I'm including by various state users over time. Those of you who are old enough to remember the field in 2004, when the IBA guidelines on conflicts of interest were first issued, will remember that they were widely ridiculed at the time, particularly for the green list and the orange list, which were thought to be, I think many arbitrators would have said they were infantilizing, you know, that they were so simplistic, and they were simplifying complex judgment calls. And yet the reality is that 16 years later, they are extremely widely invoked by the arbitrators themselves. And they have gradually gained adherence. And also there is a consensus that has emerged, I think, about how to apply them. And so the question is, should we now take a code of conduct which has just been drafted and which is not, you know, tested, and mandate its application by means of incorporating it in a treaty or in institutional arbitration rules? And I think that's a very open question as well. Thank you very much, Tom.
Thank you very much indeed, James. Catherine, what are your thoughts about practical issues of enforcement and specifically the interplay with already existing procedures? And what are your thoughts on what James just said?
Yeah, so I would like to build on some of the issues that James highlighted, starting with this idea of I would say ossification versus flexibility. So I understand absolutely the impulse to say, look, when issues are this important, the impartiality and the conduct of arbitrators, and when they have such a profound effect on perceptions of legitimacy, what we really need, again, is harmonized, uniform standards that are mandatory. That's an incredibly appealing starting point. But I do think the process has itself sort of revealed that it's certainly not as easy as sort of committing to those goals, because in fact, I think there are several different goals wrapped up in that, and they might have different solutions. So one of the, I think James pointed out some of the practical problems with adopting what would be a code of conduct into what is essentially a statutory type regime. And that's why, for example, when we talk about, and this does vary with some countries, but in the United States, of course, the system I'm most familiar, codes of conduct are enforced by disciplinary agencies, bar associations in conjunction with courts. And that's quite intentional to separate the sort of regulation of lawyers from the statutory regime. And also there is, and again, pardon me for using the United States as an example, and I think the other point that James makes that's very important is not just that you know, these might evolve over time, but actually it's healthy if they evolve over time and have the room to do that. And also I would say, I don't think as appealing in the abstract as uniformity is, there's a competing view that actually experimentation and differentiation might have value. And let me give you a specific example. So I know, and I believe this does come from the state's mandate, and again, I appreciate where the impulse comes from, but there is this idea that it should be both all courts that deal with ISDS cases, all adjudicators and arbitrators that are governed by the same code. And I think that's problematic because particularly, for example, most codes, when they're implemented for judges, are implemented by the court in which they operate and attached to an enforcement procedure within that court. And I think it would be a terrible loss and I think counterproductive to some of the reasons why certain states and entities are pushing for the establishment of a court if you then, in a sense, outsource both the content and the enforcement of ethics of those adjudicators. And some perfect examples: the International Criminal Court for the Criminal Tribunal for the former Yugoslavia was one of the first, had early codes. The International Criminal Court has a code of conduct for the judges participating in those proceedings. The ICJ in many ways is a bit of an outlier in its in not having a formal code and formal procedures. But even there, I mean, they have some, if it's not reduced to a code, it's internal to the court structure and also to the courts. I would say, ethics cannot entirely be divorced from the social protocols and the procedures through which they're enforced. That's why I think that even if I appreciate the impulse, there's something lost at both a regulatory and potentially a substantive level if you try to have too much uniformity, including between bodies that operate very differently. Standing courts and arbitral tribunals. So I would suggest that actually, as an attempt at uniformity, should in fact be rethought. In terms of the other challenges, I think there are a number of practical challenges in trying to, that I think have already been sufficiently addressed about when you call something mandatory law. To what extent does it actually become that, especially when you have all these other examples outside of ICSID? And what we say, well, and I think May Ray's point was well taken, that the vast majority of cases are ICSID, so you would have a great deal of harmonization, and you would just have a percentage less than 50%. And I don't know exactly where that percentage is when you take into account some of the statutory and contract claims that James referenced, but some percentage, perhaps less than 50%, that are not going to be covered. And I think the concern there is if the code purports to be universal, if it purports to apply to every entity, but in fact doesn't, once again, I think you create a sort of cognitive dissonance, or perhaps even a lack of confidence. If you state one level of application, and in fact it looks like it's not being complied with. I want to go back also to some comments that David made earlier. Just as I think that there might be multiple instruments here, and that I don't think there should be a terrible fear. I think they should be consistent, but I don't think there should be a fear if they are not absolutely equivalent in every place. Consistency and universality, I think, are different and are okay to be different. But I also think as the work continues on these really hard issues of enforcement, that there does need to be more work done on also how, on different types of enforcement outside of mandatory regimes. So it was mentioned that there might be reputational sanctions. I think also a lot of the, from what I understand, frustrations that are coming up leading to some of these what are called ethical reforms are actually concerns about the marketplace. There aren't enough arbitrators. So if the states keep appointing the same arbitrators, it's probably because, as a market reality, there are less arbitrators that are seen to be desirable as appointees by states. That, to me, suggests that there might be a market problem. In addition, I think I agree with what James said, that it is a little bit difficult to say, okay, well, you have to disclose all of your publications, and what happens if you're found not to have? Does that create a greater crisis of confidence than the broad disclosure sort of counterbalances? Maybe that's also at some level a market problem. Maybe one of the problems is that states or parties do not have the tools readily available to be able to search and identify the relevant publications. Now with increases in technology, that might be a problem, again, a market problem that can be more easily resolved. I also think that to some extent, some of the enforcement mechanisms might also be not necessarily the sort of nuclear options of refusal to enforce an award, or involuntary removal of an arbitrator as opposed to recusal of the arbitrator. But you might start thinking about some other types of mechanisms that could increase confidence, especially if people have a greater disclosure. And that is a thing, is a bit of a firebomb, and I didn't forewarn my co-panelists about this, but things like, for example, preemptory challenges. could there be, if what's really problematic, for example, with repeat appointments and issue conflicts are not things that can be resolved structurally by a rule that says this is permitted, this is prohibited, perhaps you could revert it back to some sort of level of party agreement, so that there might be some number, as you do with juries, once again, apologies for the US reference, that you can preemptively strike an arbitrator, even if it's not part of the code of conduct. That ability, that procedural power in the hands of the parties might actually do more to create confidence in the structure of the tribunal that it's fair than mandatory rules where you have to have an external source, whether it's the co-arbitrators under ICSID rules or some external body or an annulment panel later decide whether a particular conduct that arguably was inconsistent with the code was also sufficient to rise to disqualification or annulment standards. In other words, and I'll just stop here so we have enough time also for questions, is that I think in thinking of enforcement standards, we need to expand the toolbox beyond just disqualification and potential annulment of an award. I think that there could well be an entity that's created, but I think the market of information can also be very valuable. One thing that's not in the code that might be interesting to include is disclosure of previous disqualifications or challenges. Just a listing of those might be interesting or helpful. And if not, the arbitrators being required to disclose that, perhaps some third party, a neutral body, an arbitral institution, just aggregating that information could be very helpful and itself a sort of deterrent. So with that, again, I want to compliment, I think this might be my last time speaking, I want to compliment the people who've been working so hard on this. These are really complex, multifaceted, difficult issues with no easy answers. Really easy for me sitting here after the drafting, and all of us, I would say, to say, okay, here's what you could have done better, should have done better, might do better in the future. It's just an incredible task, but also an incredibly important one. So I look forward to seeing the future work.
Thank you very much, Catherine. And indeed, it would be a terrible world if the remedy, the enforcement remedy would be that the award becomes unenforceable for every ethical issue. So I appreciate your thoughts. Myray, what are your views on appropriate enforcement of code provisions, and what do you think the state expectations would be as to that?
Thank you, Tom. On the question of compliance of the code in a particular proceeding, this is perhaps where one of the issues in which states may want to focus their attention during the next consultation process, because we definitely need further discussions. The last time this topic was examined by the Working Group 3, the topic generally the code of conduct, the group did raise various questions on enforcement, but they were not at a stage of discussing actual practical responses or solution, nor was there a particular consensus on how to address the issue. Having said this, as David mentioned at the beginning of the session, there was some consensus among states that relying only on voluntary compliance would not be prudent, and that the consequences for non-compliance needed to be clearly set forth. But perhaps states do need more data or information on what Meg mentioned earlier on, namely that if you look at the vast majority of cases, voluntary compliance works well in order to make sure to what extent and what perhaps are the particular issues that we need to focus and that we need to look for solutions. To assist in further responding to some of the questions posed by state delegations, from my perspective, the discussion can be divided into two. And this might have been already mentioned, but with, of course, regarding the provisions relating to independence and impartiality of arbitrators. Once the code is agreed upon and implemented in particular proceedings, we will see them appearing in challenging provisions. and thereby informing the content of the standards and being able to further clarify and perhaps respond to some of the questions that Catherine and to a certain extent also James had mentioned. And this, of course, it's the main enforcement mechanism envisioned by all. It will take time, but it will be one of the ways in which we will see what is the content of those provisions. On the other ones, those that perhaps don't relate primarily to independence and impartiality, or to the provisions, for example, as the ones relating to disclosure of all the previous publication and all the previous presentations by the adjudicator, which were not necessarily meant to be included in the code in order to be the basis of a challenge, but in order to make sure that everybody has the same information. Then there perhaps we could think of monetary reputational sanctions. But it is indeed a difficult question. On the question of reputational sanctions, perhaps this indeed can be addressed through increased transparency. Through the ICSID amendment process, it was at some point being considered giving some publicity to the compliance or lack thereof of arbitrators or adjudicators with the timeframes for the issuance of awards and decisions provided in the new rules. So if this mechanism is finally adopted, that could very well assist or be used for the purpose of also ensuring compliance with the obligations set forth in Articles 3C and Article 8 relating to the duty to act with diligence and efficiency. So we already have perhaps in place other mechanisms that may help enforce the articles included in the Code of Conduct. Generally, we do believe that greater insight into the adjudicator's conduct and track record, such as perhaps what Catherine mentioned a few minutes ago, mainly having a list also of prior qualification or challenges, could help and could encourage self-regulation and voluntarily compliance with the draft code. On the question of monetary sanctions, which is another one of the type of enforcement mechanism that is regularly mentioned, it does raise the question of who should impose the financial sanctions, as Meg mentioned at the beginning of the panel. But we would add that another big question is for what type of non-compliance. For example, while it may be easier to establish that a failure to comply with an adjudicator's obligation not to engage in ex parte contacts or not to delegate their decision-making functions set forth in Article 7 of the Code could very well give rise to non-payment of adjudicators' fees or other financial sanctions. This may be more difficult with, for example, the disclosure obligations set forth in Article 5. So we think monetary sanctions are a mechanism that could be useful for some provisions, but that may be ill-suited for non-compliance of all provisions of the code, and thus it needs further consideration. Now, as our discussion progresses, we suggest in any case that our efforts be placed on finding alternatives to ensure compliance ex ante and outside of the realm of recusal and in challenges, because at the end of the day, the disqualification is a sanction that affects mainly the parties to the proceeding more than the arbitrator or adjudicator. And more importantly, states have been requesting clear ethical standards to improve the conduct on proceeding, and in an effort to make sure that they are reviewed by independent and impartial adjudicator, and not because they want to find sanction, not because they want to sanction the adjudicator. Therefore, and with this I'll end, when designing the enforcement mechanism, we may want to switch from considering how to impose or implement sanctions when ethical rules are not respected, and perhaps better think creatively and outside the box about ways of incentivizing compliance with the code throughout the proceeding. And with this, I thank you for your attention.
Thank you very much indeed, Myra. Those are very interesting ideas for multifaceted implementation by a variety of sanctions. Meg, the ICSID has a very well-developed and robust system of dealing with arbitrator issues, and specifically by way of challenges against arbitrators, which in the ICSID system are actually decided by the other panelists. It does not have a specific way of implementing alternative remedies or enforcement remedies by way of monetary sanctions or reputational sanctions. So what are your thoughts about the issue of enforcement of various code provisions?
Thanks, Tom. First of all, just to make clear to everybody, ICSID's remedy whereby the other two arbitrators decide a challenge of the third, that only applies in that kind of a situation. If there's a challenge to two or all three panelists, it goes to the chair. And I should note that as well, if the two feel they cannot decide, it goes to the chair. And I can't remember the numbers offhand, but a fair number are going to the chair. And if you look at our amendments proposed at this point, it would make it, I think, perhaps even easier for it to be sent to the chair for a decision from, instead of having the other two arbitrators. In terms of the enforcement mechanisms and other enforcement mechanisms, at this point, you're right. The enforcement mechanism is challenged. Perhaps one might look at annulment as an enforcement mechanism. I don't even think that's the right language, because it would only be, is there the possibility of annulment because whatever was the fact leading to a challenge also violated one of the grounds in 52. So I guess that's not even the right language. Obviously, we're very, very much open to listening and to discussing this. But at this point, I see a lot of problems there. And so we've got to do this very, very carefully. Things like, I mean, you just think about monetary sanctions. You know, for all but the most bold and intentional violation, is that really appropriate? And I find it hard to know what the circumstances might be. I mean, the devil is always in the details with this kind of stuff. So I look forward to the discussion. The idea about an advisory committee or the advisory council, as I understand it, again, that is very much a nascent idea. We've all been talking about this for years, but the specifics aren't there. But that even itself raises conflict issues. How can it be that a group that is meant to advise states on liability issues is going to then discipline those independent arbitrators? There are all sorts of those questions that when you start digging below the surface, they're tough. So we have to do the hard work, but to be honest, my preference would be at this first point to actually say, what is the code? How can we, what are the obligations? What are we expecting people to live up to? And how do we make that very clear before we get into the enforcement part? I think that first part has got to be elaborated better and more clearly so that it's a fair expectation that an arbitrator can comply with it, and fairly that, you know, a challenge that is strategic as opposed to bona fide also will not be well considered. So that's where at this point I think the time needs to be put.
Thank you very much, Meg. David, you have the last word. You know, how do you see this going forward?
Thank you very much, Tom. That's a lot of responsibility there. But I'll keep it short and also in hope of a couple of questions from the floor. And I saw one question in the chat. If it's okay, I would probably briefly address this one regarding the involvement of bar associations in the process. And from the perspective of the Secretariat, I can just say, I briefly looked this up. We have as observers in Working Group 3, the Inter-American Bar Association, as well as the IBA. I'm not sure if I maybe missed other bar associations that are also that also have an official observer status. But also, in addition, we are always welcoming submissions with comments on the draft code of conduct from interested individuals or associations. This regarding the involvement of bar associations. Of course, thank you to the ITA for organizing this series of webinars, which I'm sure was a very valuable contribution to the discussion as we are approaching the 30 November deadline for submissions on the draft code of conduct. And I think there were a lot of very interesting and important observations and concerns from the practitioner's point of view, but also the academic and state point of view, which we will have to address, or which will have to be addressed when further working on the draft. And I think it's fair to say that there are still a couple of things that we have to figure out, in particular regarding the implementation. With that, I'm looking forward to see probably some of you in actually not even 2 weeks from 5th to 9th October in the Working Group 3 session, where we will not discuss the Code of Conduct, but the implementation or the multilateral instrument is on the agenda for the session. And if you allow me to quickly give an outlook on the other topics that we will discuss in this session, that's shareholder claims and reflective loss, dispute prevention and mitigation, the interpretation of investment treaties by the treaty parties, security for costs and frivolous claims, and multiple proceedings and counterclaims. And with that, I'm at the end. Thank you very much, and see you soon.
Thank you very much, David, and thank you to all of the presenters for their really well thought out and incisive comments. We have a little bit of time left, and I think there are a couple of questions that ought to be addressed. First, there's a really wonderful question about any consideration that we've given to what will be the due process provided to the arbitrators in challenge or other enforcement proceedings, given that, let's face it, so many of the challenge applications these days are done for rather purely tactical reasons. I know the draft code does not address this, but giving our august panel, ought we put something in the code about due process provisions for arbitrators?
So Tom, if no one else is going to jump in, and we only have just a minute left, I will say a couple things. First of all, I think before you talk about sanctions, you have to talk about arbitrator immunity, which is actually in place, and ICSID has a very special, unique form of immunity that's much more absolute, rising to the level of diplomatic immunity for arbitrators. So I think if you talk about sanctions, the reason why that immunity exists is to avoid having parties essentially who cannot substantively appeal, cannot avoid enforcement of the award, taking out their frustration on the arbitrators. And so the existence of immunity is seen as a way of ensuring decision-maker independence. So not looking over their shoulder, ruling because they're worried about getting penalized later. Immunity does, under other regimes other than ICSID, I think ICSID's again is quite special because of its status, but there are exceptions outside the United States, which actually has an absolute form of immunity for arbitrators. There are exceptions, for example, for bad faith, so bad faith non-disclosure. I think there is some ambiguity about whether, for example, a reduction in arbitrators' fees otherwise earned in an arbitration are an exception, fall under or prohibited by immunity provisions or not. But I think the separate question that was raised is due process. Assuming we get to the point where we say, okay, yes, there might be some sort of monetary or other sanctions for an arbitrator. Do you allow the due process? What kinds of due process are allowed? I would say here that there are some models, both based on judicial context, and also the Chartered Institute of Arbitrators has come up with a process, but it has to be attached to some sort of body, some sort of regulatory body. But they do have essentially a due process protocol for arbitrators who are sought to be sanctioned, and the most severe sanction is expulsion from the Chartered Institute. Again, since investment arbitrators aren't regulated formally, don't have formal professional qualifications, that it's a little bit of a different regime. But it is possible, but it's a whole separate range of considerations, starting again, I think, with immunity.
Do we have time for one more comment, or are we out of time?
Please. I think we'll go over it by a few minutes, but that's fine.
Okay, I just wanted to follow up on something Meg said, because I think it's important when she expressed hesitation about going beyond the traditional remedies of things like disqualification. When in the LCIA, in our last version of our rules, we adopted a code of conduct for party counsel. And we were the first institution to incorporate that in our rules. And at the time, we considered the question of what should the sanctions be. And many people were dissatisfied that we basically had an escalating list of largely precatory and admonitory remedies. You know, you tell the council that, 3 strikes and you're out, or something like that. And so the proposal was made that the tribunal ought to be able, in cases of violation of the code, to recommend a sanction or to notify the bar of the offending counsel. And that precipitated a big discussion. And I think at the end, we concluded, and so I think a lesson might be drawn from that here, that an institution and the arbitrators administering a particular proceeding should concern themselves with the proceeding. That's their duty, is to make sure that the proceeding is fair. And it's really not their duty to try to ensure reputational harm for an offender. I mean, that is really beyond their scope. And it's up to individual counsel who are offended by it or who are aggrieved by it to go to the regulatory bodies like bar councils and ethics councils of court administrations. And I think that's a respectable view. That's the one we adopted in the end. And so I just pass that on for what it's worth.
If I may follow up with that very, very briefly, Tom, really, because I know we are running out of time, but I think it's interesting because the more I think about the question of enforcement and remedies, and also the more I hear about the views of the different panelists, I think the idea of establishing a committee, like an implementation committee, which is different from an advisory committee, but a committee that is neutral, but representative of different arbitral institutions, but outside arbitral institutions and represents the community, I think that would be a very interesting mechanism to implement the code. So a neutral authority that sits outside administrative arbitral institutions that administer proceedings, but at the same time has the authority to, for example, look at the challenges procedures and possibly issue a list of names, and kind of act as a bar authority in a situation where a bar authority doesn't really exist because of how ISDS and in general international litigations work. And I wonder, I don't know if you have time to hear, views from the panelists about the establishment of the committee, or maybe another time. But I think this is something. The more I think about it, the more it seems to me like a kind of a possible way forward.
It seems to me, Kara, that that is a very intriguing idea, but the devil's sort of in the details about how it would be set up and who would sit on that committee. I'm always amused by the fact that there was a Human Rights Council of the UN, and Libya under Gaddafi was put on it because they had such a stellar human rights record. So it's all about who actually sits on that committee and who's appointed. Did anyone want to comment?
I will say one perhaps similar in function, but perhaps less challenging in terms of creation. I do, and again, because of my position at Arbitrator Intelligence, I can't disavow, multiple incentives for this. But part of the reason I, have been working on that project is because I do believe a lot of these problems are really informational. and that aggregation and analysis and facilitation of information will end up solving, a lot of, so at least many of these issues, or at least making them more manageable. And an independent information aggregator, whether it's arbitrator intelligence or someone else, can, I think, provide a regulatory function without the decision making that actually ends up being where all the harder questions are. And again, something as simple as just aggregating all the challenges to arbitrators. A lot of, also with investment arbitration, a lot of this is public, but it's not easily accessible, or it's incredibly expensive to be accessible. And I think, again, some of the analytics that are being done now about relationships between arbitrators and law firms and entities, it can go a long way to giving a clearer picture on some of these deeper, bigger questions that are too nuanced to be addressed through broad disclosure. I don't think broad disclosure solves all that, but I do think that the inclination towards disclosure is an inclination about information. People, parties want more information. The question then is, what do you do with it? And there's a separate set of questions attached to that. But I don't think, and again, acknowledging multiple hats here myself, is I do think that one of the better solutions for information is how to manage it in a way that's accessible, rather than just throw it all out there on a case-by-case basis, which I don't think does parties all that much good.
Catherine suggests that, in fact, there may be market and even technology solutions to some of the issues that may be difficult to address by way of a direct challenge or annulment sanctions. Listen, thank you very much. We've gone over a little bit, but I really wanted to thank our really distinguished faculty. It was a great discussion. These are profoundly complex and complicated problems. But I think this is one of the best discussions yet I've heard about the proposed code of conduct. I hope this will all be taken on by the delegates of the member states and further thought given in the next implementation, next version of the draft. So thank you to our faculty. Thank you very much to the audience for sticking with us on a Friday night in many places. This has been a great program. We are so proud that the ITA was able to put on this series. We have recorded these programs, and I provide an undertaking that we will give the best possible thought on how to make those recordings available to the greatest number of people in the shortest possible time. So maybe the recordings will also be available in advance of the comments being due on November the 30th. Obviously, there's going to be another iteration of the draft code at some point after the comments are in. We very much look forward to how the code evolves with its next draft. And let me thank Joe and David and the ITA for putting on this series and allowing us to share our ideas about the draft code. And with that, Joe, any parting thoughts?
Just to say, I want to second the thoughts and the appreciation to this faculty, and for not the last time again, thank you and Tom and Chiara for putting this together, for organizing it, for thinking it through, and for recruiting this truly spectacular faculty. It's been a great program, and as I said at the outset, ITA is very proud. Thank you very much.